This episode of The Court Show is brought to you by Elite Automotive Repair in Mountain Home.
State versus Joseph Killinger, 17-39, possession of paraphernalia.
This is a re-up here for Mr. Killinger. He has a parole revocation. The hearing was scheduled for Monday. It was continued. They have not reset a date, so there's no point in talking about bond or anything else at this point until we've resolved this.
Okay, sir. Let's leave it as scheduled.
All right.
State versus Kayla York, 17-33, possession of controlled substances and paraphernalia. Morning.
Morning.
Ma'am, I'm looking at a police statement and some conditions of suspension or probation. Have you gone over these documents?
Yes.
Okay. And is this your signature on both of them?
Yes.
All right. You come just a little closer so we can hear you a little better. Do you understand what's set out in these documents?
4 years probation.
Okay.
4 years probation and the First Offenders Act.
You understand the charges against you and the range of penalties if you're convicted?
Yes, sir.
And is it correct that you're pleading guilty to possession of methamphetamine and possession of drug paraphernalia?
Yes, sir.
When you plead guilty, you give up your right to have a trial, and you also give up your right to an appeal. Do you know that?
Yes.
Are you entering this plea freely and voluntarily?
Yes, sir.
Has anyone promised you anything other than what's in these documents?
No.
Okay. Has anyone pressured you or threatened you to get you to do this?
No.
And are you pleading guilty because you're in fact guilty?
Yes.
Okay. On or about January 11th of this year here in Baxter County, were you in possession of some methamphetamine and some paraphernalia?
Yes.
Okay. This time I'm accept your plea. I sentence you on each count to 4 years in Department of Correction to be suspended. This will be under it doesn't say it here, but is this 346?
It is, Your Honor.
Okay, under 346. You'll pay $200 in cost, a $1,000 fine, a DNA fee of $250, a $20 booking fee, $200 in public defender fees, and a drug crime assessment of $125. And pay what you owe at a minimum rate of $100 per month beginning within 30 days. And you make your payments to the Sheriff's Department here in Baxter County.
Okay.
Paulson, I'm looking at a police statement and some conditions of suspension or probation. Did you go over these?
Yes.
And did you sign both of them?
Yes.
Do you feel you understand what's in these documents?
Yes, sir.
You understand the charges against you, the charge, I guess, and range of penalty if you're convicted?
Yes, sir.
Are you pleading guilty to furnishing, possessing, or using prohibited articles?
Yes, sir.
By doing so, you're giving up your right to trial and appeal. You know that?
Yes, sir.
Are you entering this plea freely and voluntarily?
Yes, sir.
Have you been promised anything other than what's in these documents?
No, sir.
Has Mr. Bailey or anyone threatened you to get you to change
No,
your
sir.
plea? And you're pleading guilty because you're in fact guilty?
Yes, sir.
Judge, this was filed as a Class B. The state's agreed to reduce that to a Class C felony, just for the court's information.
It's filed as a B, so, okay, that'll be allowed.
Going on December 22nd
Okay.
of last year, this defendant was being booked into the Baxter County Jail, and she had in her possession approximately 4 pills, alprazolam. That's the
Okay.
nature of this charge.
Is that right?
Yes, sir.
This time I'll accept your plea, judge you guilty, sentenced to 5 years in the Department of Correction,
10. I was
be
just about to-
suspended. You pay $200 in cost, a $1,000 fine, DNA fee of $250, $20 booking fee, $200 in public defender fees, and a drug crime assessment of $125. Pay what you owe at the minimum rate of $100 per month, beginning within 30 days. Make your payments to the Sheriff's Department in Baxter County. Okay.
Yes, sir.
Judge, there's a a companion case to this that's a revocation, and we have a resolution to that too. I don't know if the case file's over here.
Okay.
16-389 is the case number. They did.
They did, you saw it. I don't have-
Ma'am, I'm looking at a petition which was filed to revoke your probation in 16-389. And it's alleged that you committed offense of furnishing privileged articles, a felony while on probation. You have a right to a hearing on that, which the state could probably prove since you just pled guilty to that. And that you can plead true, but you give up your right to the hearing and an appeal. Do you understand that?
Judge, we are going to enter a plea of true, and the disposition will be the same as in the case that she just pled to. That it'll be 5 years probation.
Yes, Your Honor, we're going to increase the probation.
Okay.
3 years to life.
I'm going to find that while on probation, you violated terms and conditions of your probationary period. I would revoke your probation in 16-389 for possession of controlled substance methamphetamine, your possession of drug paraphernalia. You're sentenced to 5 years probation. For shoplifting, again, you're sentenced to 30 days to county jail. Possession of trazodone, 1 day in the county jail. You're to get jail time credit of 25 days. Okay, previously it was a 346. Is this turned into a conviction?
It
now?
does, Your Honor.
Is that your understanding?
It would have to, Your Honor.
Again, you're ordered to pay $200 in costs, a $1,000 fine, a DNA fee of $250, a $20 booking fee, $200 public defender fee, drug crime assessment of $125. Pay what you owe at the minimum rate of $100 per month, beginning within 30 days after your release. Let's see, how much has she got? Has she done all of her time now?
By now, yes, Your Honor. She had 25 days before, and she's been in for several days this time.
You just go with this gentleman here. State versus Barry, Fowler, 16-410, which is drug case, 16-372, theft, 16-131, a drug case.
Your Honor, I think these are on your docket today solely. I think the court's already signed a revocation of bond in all of his cases.
Let's see, maybe,
I believe it was Judge Webb. It was Judge Webb who revoked this man's bonds, Your Honor.
okay. That's right.
Your Honor, Mr. Fowler is represented by the Public Defender's Office. When I had met with him yesterday at the jail, he has two bonding companies that he has used. He's used Exit Bonding and he's used RRR. Ron from RRR is here. And I know that Ron would stand good on his bond if the court was willing to reinstate that bond.
Why was the bond revoked? That's a good question.
Your Honor, if I can speak to that. Mr. Fowler was arrested May 16th of last year. That was for a drug-related charge in 16-131. He posted a $5,000 bond. He was then arrested on November the 9th, 2016. I was in case 16-372, again, drug-related charge, the sale of drugs. He posted a $50,000 bond. He was arrested December 14th, 2016. That was in case 16-410, again, the distributor selling a controlled substance. He posted a $30,000 bond. He was arrested November 7th for a misdemeanor, the possession of a controlled substance, where he posted a $685 bond, got out of jail. Then he was arrested January the 12th of 2016, where he was arrested, he was allowed to post a $710 bond. He has since been arrested, Your Honor, and charged with other charges. Your Honor, this man needs to sit in jail until we have his trial so that we can get, at least the state can get the opportunity to bring the charges against this man. One of the criteria for holding a person at bond, I'd like a $200,000 bond, or I'd like a $50,000 cash bond. It is incredible to me that a person that can make $87,000 in bonds is standing here with the public defender. But that's not the subject for today. The subject is, should you let Barry Fowler out of jail? And yes, you should. Just as soon as he can come over here and we can have a trial so the state can get the opportunity to send this man to prison. And he needs to sit right there. I realize you have to set him a bond. I'd like you to set him a $50,000 cash bond. I'm tired of, Judge, we're putting this man, and I've read his affidavit. This man doesn't have an income. I think he got a $573 income beginning in August. This Mr. Fowler has to sell drugs to pay his bonding company. So we're actually getting this man out of jail and telling him, you got to pay your bondman something each week. He's got bills to pay. I'm sorry that he's where he's at. But if you let this man out of jail, he has to sell drugs. That's what he's been doing for 10 months.
What is his source of income?
Henry, he could address that better than what I could.
Does he have a job?
Barry, tell the court what your source of income is.
Disability,
And your total amount of disability?
570.
And you have no other source of income?
No.
Your Honor, if I could briefly respond to Mr. Chisholm, he makes a passionate argument about keeping Mr. Fowler in jail. However, these are allegations, these are not convictions, and that's why bonds were set to begin with. Mr. Fowler is entitled to have a reasonable bond, and the bonds that Mr. Chisholm has suggested, $200,000 to total, is way out of proportion for these type of offenses, or a $50,000 cash bond is totally inappropriate.
Judge, give this man a $5,000 cash bond. He's been arrested 4 times for selling controlled substance in this county. Other than that, heck, let him go. But if we're under the illusion that this man isn't going to sell drugs, then hey, let him out of jail. But I mean, let his bonding company say, I'll stay on his bond so he can get out of jail. The man's living on $570 a month. He can't live on that, Your Honor. Nobody in this room can live on $570 a month.
Not without hell, probably.
Give him a $5,000 cash bond, and let's hold that. And I hope he can't make it, because I would like him to come to court and be tried. It's time.
Yeah, 5,000 cash. That's all we can do today. Thank you. State versus Janet Brigman, 16-307, bond revocation, 16-295, 15-293. Good morning.
Judge, I'm sorry.
Go ahead, sir.
Judge, Ms. Brigman's bond was revoked. I'm not sure procedurally if it's a contempt, or I don't think I have an actual revocation order. However, we're here to request that the court allow her to stay on her original bond. One of the issues that Ms. Brigman had was that she was required to wear an ankle monitor.
Right.
She's of limited means. She did it for quite a long time. Then she was evicted from the home she was staying in and literally didn't have a power source to power the ankle monitor. But she had it on her up until she was arrested. She did, Jana, you put up a bond as well as the ankle monitor, correct, with First
Yes.
Arkansas?
Yes,
Okay.
10,000.
So Judge, she has made a bond to secure her reappearance. Her co-defendant in this matter had pled out last week, I believe, and he's now on probation. We would just ask that the court reinstate her bond without the ankle monitor.
Why was her bond revoked from your file?
Judge, she was required under the terms of the bond that you set for her when we reduced this lady's bond the first time, that she have an ankle monitor. And that was after she had posted a bond after being arrested in September of 2015 and then being arrested twice in 2016. She's got 3 pending cases. This court allowed her to bond out of jail based on the fact if we can monitor this lady on an ankle monitor. She can't do that. Her ankle monitor did not function because she did not charge it. Judge, this lady can't afford an ankle monitor. She can go back to jail until we can do it. Judge, we've visited this.
5,000 cash.
Thank you.
I'm sorry, Your Honor, what was that?
5,000 cash.
Okay. She's set for trial coming up in a couple of weeks, so.
Yeah.
I can do an ankle monitor.
I'm sorry?
I can do a ankle monitor.
Do you have a place to stay now where you could power it?
Yes, I do. It was charging before I got arrested. I charged it every day for that whole week of being in between homes.
I guess the question would be then, Judge, if she can
definitely-
comply. Hold on, Jana. If she can comply with the ankle monitor,
Was she arrested? Again, why was it revoked? Because she was...
Judge, she was revoked for not charging her ankle monitor and also moving without telling us.
Oh,
I did so till I was given permission through my lawyer and you. He came out and said that you said I was okay to move.
Jana,
because-
what happened was let's not revise history. When we spoke, I said, get me an address, and you got me an address, and you were
Yes.
arrested the next day. So that
Oh, I
was,
got you. I called in an address like 4 or 5 days prior to my
Okay.
arrest.
okay. We can have a hearing. Maybe we need to have a hearing, a further hearing if you want to present more evidence, and you're entitled to that.
Judge, we got a trial coming up in about 2 weeks.
Judge, I just think, I mean, it's punitive to Ms. Brigman. She's trying to live. She's been arrested while she was out on bond. We cannot deny
Who
that.
put the monitor in? I'd like to hear from this person,
Who,
Freddie Thompson, Your Honor.
Brady Thomas. Well, let me think about it.
all right.
Obviously, there's some problem. I'm gonna think about it, man. State versus Frank Collins. 16-162, possession of firearm by certain person. 16-94, similar charges. Frank Collins, is he in jail?
He is, Judge.
Oh, he also has some drug charges too, I see.
His case files, you may want those. Judge Frank, we're here on a bond hearing for Frank because he's already made $28,000 worth of bonds. At some point in time, he was arrested, I believe, on a misdemeanor charge, and he's finished with that charge. I just want to I got him on the docket today to be clear that he has already posted those bonds. He is out on bond on these charges. So what we would request is that if his bondsman, who I've spoken with this morning, will file something with the court saying they'll stay on those bonds, that he be released on those bonds that he's already made.
So why is he in jail?
He had a misdemeanor offense that's been, I believe it's already been taken care of, right? That's over with?
Yeah.
Okay.
Yeah.
It appears on the jail's website that he was charged with a new offense, but he wasn't.
Judge, I didn't revoke this man. I thought he was just here on a reappearance. I noticed that in the file that he was charged March of 2016 with about 4 charges. His bond was $3,500. I assume he made bond on that. He was charged in May of 2016. He was charged, he had a $20,000 bond, but I did not.
It might have been a misdemeanor bond revocation. So I'll clear that up with district court. But as long as we're clear here that those bonds still stand good, he can be released. Is that correct?
I think he's got a trial coming up.
At March 30, yeah.
March 30.
Well, if he's not, he shouldn't be held, we need to release him.
Thank you, Your Honor.
Your lawyer's working on it. It doesn't appear you're being held by circuit court, at least in this division.
All right, thank you.
State versus Jessica Clark, 1697. Breaking or entering theft. And 1627 must be similar charges. Jessica Clark. Well, gentlemen, where are we here today?
Your Honor,
I believe this lady absconded, Your Honor, and we just acquired her. We're trying to get her on a scheduling order. I think
Okay.
she failed to appear.
I see.
We issued an alias warrant for her on October 20th. The public defender reported they had lost contact with her. And then there was I guess we're just here but she failed to appear in June 30th of 2016, and then I guess we issued an alias warrant for her on October 20th of 2016. We just need to get her back. She may have not been gone long enough for us to.
So we need to issue another scheduling order. I assume the trial time's passed.
Okay.
And what else?
Your Honor, Ms. Clark and I had visited about a possible resolution of that case. I will tell her, without going into a lot of detail, that what she and I had talked about is different than what Mr. Chisholm and I have talked about. So I'll get over to the jail and visit with you, Jessica, but there'd be no further action in her case today.
Very well. That's all we can do today, ma'am. Thank you.
Your Honor,
Yes.
may I please ask that I get an ankle monitor and be released?
Mr. Cooper?
I have 2 small children at home
Why
that I
did
need
she-
to get back to.
Why did she not appear last October?
Your Honor, her explanation to me was that there was a plea offer on the table at that time that, if I remember correctly, involved her going to CCC for the 9-month program. And she became scared. She did not leave the area. She simply did not come back to court. But she had told me yesterday at the jail that she never left the area. She was just afraid to come in and enter that plea.
Has she got prior conviction?
I
I can check, Your Honor. I will say, Your Honor, her first failure to appear was in June of last year. This lady's been gone for 6 months.
Okay, we'll check and see if she's got priors.
I have no prior convictions, Your Honor.
Okay.
And I beg that you let me out with an ankle monitor or something like that. I need to get back to my 2 small children at home, please, Your Honor.
All right, well, the state's going to check it and confirm your lack of a record. We'll go from there. Right now, that's all we can do, okay?
What was it, sir?
Okay, the state's going to see if they can confirm that you have no prior convictions, and then I'll rule on the bond. But at this moment, that's all we can do. So if you just stand aside, but I'll.
Thank you, Your Honor.
All right, bye.